In this practice-perfect review, we will address the problem of proving negligence based on a party's violation of a statute. For a simple example, suppose that Pressler drives at 40 miles per hour in a 25 mile per hour zone and has an accident with Mullins. Mullins' counsel would want to use the fact that Pressler was speeding to prove that Pressler was negligent. Here's his argument. The legislature has mandated that citizens drive at or below 25 miles per hour, and Pressler ignored the statute. The ordinary reasonable person would obey a safety statute. So Pressler was negligent for ignoring the command of the legislature. Our question in this review is, when will a party be able to make that argument, to prove that an actor was negligent because she violated a statute? If she can, it's powerful medicine. By borrowing from the statute to set a clear standard of care, a party can avoid the murkier general analysis of whether the person acted like a reasonable person under the circumstances. Here's the most important point to understand about borrowing statutory standards of care to prove negligence. A court will only allow a party to use a statute to prove negligence if that statute was enacted to prevent the type of harm that the plaintiff suffered. Suppose that a statute limits truckloads to 40 statute to prove negligence. Important point to understand about borrowing statutory standards of care to prove negligence. A court will only allow a party to use a statute to prove negligence if that statute was enacted to prevent the type of harm that the plaintiff suffered. Suppose that a statute limits truckloads to statute to prove negligence if that statute was enacted to prevent the type of harm that the plaintiff suffered. Suppose that a statute limits truckloads to 40,000 pounds, and Popkin, a trucker, was carrying 50,000 when he hit Barry's car. Well, if the statute was enacted to protect the roads from excessive wear, then it was not enacted to avoid road accidents, and Barry would not be able to use it to prove negligence of Popkin. But if the weight limit was enacted to make sure that large trucks could stop in a reasonable distance, then the statute may well be relevant to Barry's accident. Because the truck was overloaded, it could not stop as quickly as a lighter truck, which may be a cause of his collision with Barry. In that case, Barry could use violation of the statute to prove negligence, because the statute was aimed to prevent the type of accident that Barry suffered. In other words, the statutory violation could be regarded as negligence per se, negligence in itself. Here's another example of the statutory purpose doctrine from a famous English case. In Goris versus Scott, a statute required animals of different types being carried on ships to be kept in separate pens to prevent the spread of disease. The shipper did not pen the sheep on board, and they were washed overboard in a heavy storm. The owner of the sheep argued that the shipper was negligent per se, because he violated the statute requiring that the animals be penned. But the court held that the sheep owner could not prove negligence based on the statute, because it was aimed at preventing disease, not preventing animals from being swept overboard. Of course, the owner of the sheep could still prove the shipper was negligent under the reasonable person standard. He just couldn't use the statute to prove it. Here's another example. Suppose that Larson violated a statute which bars driving with a noisy muffler, and he collides with Meta's car. Could Meta prove that Larson was negligent by proving the violation? Well, if the muffler statute was enacted to keep peace in the neighborhoods, to keep them quiet, then Meta couldn't use the violation to prove that Larson was negligent, because it was aimed at keeping noise down, not preventing accidents. But suppose that the legislature enacted the statute, at least in part, to make sure that drivers could hear horn warnings from other cars. If that was the statutory purpose, and Meta had honked her horn to warn Larson that they were about to collide, then the statute would be intended to prevent the kind of accident that happened. And on those facts, Meta could introduce evidence of the violation of the muffler statute to show that Larson was negligent. The third restatement of torts articulates this statutory purpose doctrine as follows. An actor is negligent if the actor violates a statute that is designed to protect against the type of accident the actor's conduct causes. Okay, let's suppose that Larson, the defendant in Maida's case, did violate the muffler statute, and that it was enacted to make sure that drivers could hear warnings while driving. In a jurisdiction that treats a violation as negligence per se, Maida will present evidence at trial that Larson violated the muffler statute to prove that Larson was negligent, and the judge would instruct the jury as follows. If you find that Larson was driving with a noisy muffler at the time of the accident, in violation of State Highway Code Section 114, then you must find that Larson was negligent. Under this instruction, the jury would be required to find Larson negligent if it finds that he violated the statute. That's powerful medicine. The violation leaves the jury no choice but to find Larson negligent. However, even if the violation establishes that Larson was negligent, Maida must still show that the violation caused her injury. Suppose, for example, that Maida never honked her horn before the accident. Then, even though Larson violated the statute, his noisy muffler did not lead to the accident. It would have happened the same way if he had a quiet one. So the statutory violation may show that Larson was negligent. Element number 2 of the claim for negligence. But not that his negligence led to the plaintiff's injury. That's element number 3, causation. In one of the classic cases, Martin versus Herzog, the plaintiff drove his buggy without a light after dark, in violation of a statute, and his buggy collided with Herzog's car coming the other way in the dark. In Martin, the court held that failing to have the light as required by state law was negligence per se, because having a light was intended to allow other vehicles to see the buggy. So Martin was negligent for violating the statute. But suppose that the accident happened because Herzog ran into a deep pothole, lost control of his car, and swerved into Martin's lane. On these facts, Martin would still be negligent per se for driving without the light, but the lack of the light would not be a cause of the accident. Martin could have had 10 lights on his buggy, and the accident would have happened the same way, so no actual causation. Okay, so a party can often prove that an opposing party was negligent for violating a statute. But in all jurisdictions, when a statute is used to prove breach of the duty of due care, the party who violated the statute will be entitled to introduce evidence to explain the violation, to show that she had a good reason for acting as she did, which will excuse the violation. Suppose, for example, that Herzog swerves across the center line in violation of a statute that requires drivers to stay on the right side of the road. In a jurisdiction which applies the negligence per se doctrine, proof of that violation will establish that Herzog was negligent. But suppose that Herzog did it to avoid hitting a child who ran into the street in front of his car. Surely, if that's true, the ordinary negligence per se rule should yield to common sense. The legislators who voted for the stay on your side of the road statute would surely not say that they meant the statute to apply in that circumstance. So even in negligence per se jurisdictions, a party who violated a statute will be allowed to present evidence of an excuse. Typical excuses that might be raised are a sudden emergency, such as Herzog swerving to avoid a child. The inability to comply is where a shop owner is unable to keep the sidewalk clear in the middle of a blizzard. Lack of knowledge of the violation. For example, when a driver's taillight goes out while she's driving and she doesn't know it. An actor's incapacity, as where a young child violates a jaywalking statute. Or that due to unusual circumstances, it would be more dangerous to comply with the statute than to violate it. Let's suppose in Martin versus Herzog that Herzog offers evidence that Martin had no light on his buggy, a violation of state law, but that Martin submits evidence that the light had just blown out 10 seconds before the accident, and Martin was trying to pull over when he came to a spot to do so. In this example, Herzog has made a showing that Martin violated a relevant statute, and Martin has offered evidence that might establish an excuse. What should the court tell the jury in such a case? where the party who violated the statute offers evidence of an excuse. The jury has an important role to play in deciding whether the violator was negligent. They must determine, in light of the violation and in light of the excuse that was offered, whether the party acted as a reasonable person under the circumstances. So, when evidence of an excuse is offered, the question for the jury becomes, once again, one of reasonable care under the circumstances, rather than an automatic finding of negligence because the statute was violated. Here's a suggested instruction to the jury in this example. In this case, there is evidence that the defendant violated the statute requiring a light on his buggy. The defendant has offered evidence of an excuse for the violation. If you find that the defendant violated the statute, you should consider that evidence, along with the defendant's evidence of the reason for the violation, in determining whether the defendant was negligent. This chance to excuse a violation may seem to make the negligence per se rule a toothless tiger. The violator can avoid its effect by evidence of an excuse. But the fact of the matter is that most of the time when people violate safety statutes, they don't have an excuse. They just did. And in those cases, the negligence per se doctrine labels the actor as a lawbreaker and has considerable power in establishing negligence. In closing, we should note that a few states take a different approach to evidence of violation of a statute. They hold that a party's violation of a relevant statute is admissible evidence that the party was negligent, but it does not in itself establish that the actor was negligent, even if the jury finds that she did violate it. The jury would still be free to find that the party exercised due care. Suppose, for example, that a driver drove 4 miles over the speed limit. In a negligence per se jurisdiction, this would require the jury to find the actor negligent. In an evidence of negligence jurisdiction, the jury would not be required to do so. Instead, the judge would instruct the jury along these lines. If you find that the defendant violated the statutory speed limit, you may consider that evidence, along with all the other evidence, in determining whether the defendant was negligent. If the violation occurred in the middle of the day when there was little traffic, a jury might very well find that the party was not negligent, even though she exceeded the speed limit and offered no excuse. That is a meaningfully different approach than the traditional negligence per se rule, because the jury is not bound to find the violator negligent.